Howdy, my name is JD Foster. I'm an attorney here in Ellis County, Texas. And today I want to take a moment to discuss a topic that many business owners out there may be thinking about or ought to be considering. Similarly, some employees or independent contractors out there may want to put some thought into. And that is, what's the difference between an employee and an independent contractor? Now, most people inherently understand that there's a difference between these two, but not everybody understands that this is a pretty important difference that carries a significant amount of liability, both for employers and potentially, in certain circumstances, for employees if a worker is miscategorized. Notably, there are civil and criminal penalties that can be imposed by the IRS and have been outlined both under state and federal law. That being said, I really want to caution both business owners and employees out there that if you're really not sure, or you go through this analysis and you think to yourself, I'm still not really sure which is which, then you really should consult with an attorney. And indeed, you may wish to consult with an attorney anyway, because the risks associated with this can be pretty significant. That being said, there are traditionally three major categories that are evaluated in this analysis: the behavioral, the financial control, and the type of relationship. And each of those major categories has at least a few subcategories associated with it that are evaluated in the course of this analysis. I'd like to start with the behavioral. And within the behavioral, there are four primary subcategories. And those are the type of instruction, the degree of instruction, the evaluation system, and training. In the instance of types of instruction, what's being evaluated is the degree of control that the employer is exerting over the worker. A greater degree of control obviously is going to indicate an employee, whereas a lesser degree of control is likely to indicate an independent contractor. So if your worker is being told who, what, where, when, why, and how to do their job, then it's very likely that that person is an employee and not an independent contractor. Whereas if the opposite is true, they're simply being informed this is your objective, go get it, it's very possible that they may be an independent contractor. Similarly, and somewhat related, the degree of instruction is often considered in this respect. A greater degree is often associated with an employee, whereas a lower degree of detail is often going to be associated with an independent contractor. The evaluation system mirrors this as well. An employee is often evaluated not only on outcomes, but also on how they got there, whereas an independent contractor is traditionally only going to be evaluated on the outcomes. Finally, within the behavior category, you have the training aspect. Traditionally, employees are going to be provided training as to how to do their job, whereas an independent contractor is going to be expected to show up to the job already knowing how to do it. Now, in all of these cases, you have to remember that there is some degree of a continuum, and the specific facts may change the circumstance. Next, you have the financial control major category, which has 5 minor categories or subcategories within it. That's the degree of investment required by the worker, whether or not expenses are reimbursed, the opportunities for profit or loss by the worker, ability to offer services to the market by the worker, and the methods of payment to the worker. In the case of investment, what's really being evaluated is who's providing the equipment and materials to do the job. Again, this isn't determinative, but obviously an employee is more likely to be provided their equipment and materials to do their job than an independent contractor who may be required to obtain those things on their own. Similarly, reimbursed expenses can be somewhat indicative of the classification as well, or the proper classification. An employee is often going to be reimbursed for expenses they incur, whereas an independent contractor may not be. But again, there are exceptions. Next, you have opportunities for profit or loss. Typically, an employee is not going to bear any opportunity for profit or loss, whereas an independent contractor is going to bear all of the opportunity for profit or loss on the job. However, and particularly with the advent of things like stock options provided as compensation, this line has been significantly blurred, and it may depend on a case-by-case basis on this one. Next, you have the abilities to offer services to the market. And this has become even more true recently, but employees are often not able to offer their services to the general market, whereas an independent contractor is offering their services to the general market at all times. This has become even more true with the advent of non-compete clauses and the like, and the advent of more common employment contract type documents that may contain non-compete clauses associated with the employee. Next, within the financial control segment of this analysis, the method of payment can be determinative. An employee is often paid on a regular basis, whether that be by a salary or on an hourly basis. In contrast, an independent contractor is going to be paid for the job, or in some cases in an hourly basis, but that's usually going to be associated with a specific task. Next, you have the type of relationship. Now, before we get into the subcategories associated with the type of relationship, I want to emphasize, in particular with this major category, that there is a continuum associated with these things, and that each of these factors are not determinative in and of themselves. They are considered as a group. The first subcategory for the type of relationship is whether or not there's a contract. Now, whether or not there is a contract is, again, not necessarily determinative, as the details of that contract are going to be far more instructive and are just going to be handled on a case-by-case basis. Similarly, whether or not the worker is offered benefits is going to be somewhat instructive, but also not determinative, because while employees are often offered benefits, not being offered benefits does not mean that they're an independent contractor by any means. And similarly, while independent contractors are traditionally not offered benefits, if they are offered benefits, that's not necessarily determinative either. There's a significant amount of blurring of those lines. Next, the permanence of the position is going to be very instructive. Often employees have an indefinite position, whereas a general contractor is not going to, or excuse me, an independent contractor is not going to have an indefinite position almost ever. In fact, most independent contractors are going to have a specified period of time or are perhaps contracted on a project-to-project basis. In other words, it's limited. Finally, within the type of relationship category, you have services, the type of services that are being offered. And what's really being looked at here is what type of work is the worker actually doing? Are they doing things that are a core function of the business, or are they doing things that are sort of around the fringes, just things that need to be done? If they're doing core functions, often this can be a sign that that worker is an employee. And if the opposite is true, it may be a sign that that worker is an independent contractor. Again, not determinative, but can sometimes be instructive. Now, having gone through that whole long list of analysis, I'm sure there's any number of questions that are left. And I would note, before I conclude this conversation or this discussion, that the IRS does offer Form SS8 in order to allow individuals or businesses to inquire as to their proper characterization. But it should be remembered that the IRS is not necessarily the most quick organization to deal with. Many times that can be a long process to get an answer, lasting 6 or more months. And that's important to consider because, particularly in the case of a business, if you're trying to pay somebody in the meantime, which you may very well be obligated to do, the IRS is not going to waive penalties for misclassification during that period. And the net result is that you could incur those civil and criminal penalties in the meantime. Now, that being said, I again want to urge business owners or even employees out there who may have a question as to their proper classification to seek the advice of counsel. It is something that my office can help with. And if you'd like to contact us, we're always available at our phone number, and that's 972-937-1616. Or in the alternative, you can always go to our website and go to the Contact Us form and just drop a little something in our box, letting us know what you need some help with, and we'll get back to you as soon as we can. And our website's located at www.elliscountylegal.com. Again, I just encourage you to get help from counsel if you have any questions about this, because it is a pretty significant consideration that carries some significant penalties. With that being said, thank you. Have a good day.